Good afternoon, everybody. Good afternoon. I'll just keep talking, make sure that the sound balance is good until we quiet down. Good afternoon. Thank you all so much for making it out here today for this excellent conference. My name is Joel Nolette. I'm an associate at Wiley Ryan here in town in the litigation practice there. I serve in the Federalist Society's Administrative Law and Procedure Practice Group. And I have the privilege of introducing our conversation partners for today's Fireside Chat. Before I do that, though, two things. One, I think I saw Judge Starr. Was Judge Starr sitting right there? Okay. Well, cribbing shamelessly from something I heard him once say, which is that as textualists, when we have Fireside Chats, there should be a fire. So I just want to make clear that the Fireside Chat term here is an idiom. Its original public meaning is the idiomatic and strictly idiomatic sense of the term. So that's the first thing. The second thing is, as many of you know, Alita Cass was the founding director of the Freedom of Thought Project. She recently took a new position at the Department of Justice. We are grateful for her leadership of the project for the Society and wish her much continued success. For our attendees today, there's a Freedom of Thought poster down by the registration table. Please take a moment to write her a note of gratitude before you leave today. So with that said, as for today's lunch discussion, our moderator for this discussion is Justice Sarah K. Campbell. Justice Campbell was confirmed to the Tennessee Supreme Court on February 10th, 2022, following her appointment by Governor Bill Lee. She is also an elected member of the American Law Institute. Justice Campbell previously served in the Tennessee Attorney General's office as Associate Solicitor General and Special Assistant to the Attorney General. Before that, she served as an associate at Williams & Connolly here in town. She served as a law clerk for Justice Samuel Alito on the U.S. Supreme Court and Judge William Pryor on the 11th Circuit. She went to the University of Tennessee for undergrad and then Duke for both law school and grad school, where she earned very many accolades. I must say she also wrote an excellent concurring opinion. I'm going to butcher the case name, but it's Borgny X. Rel. Hyder versus Chattanooga-Hamilton County Hospital Authority. Did I get that name right?
No one really knows how to pronounce it.
Yeah, fair enough. Fair enough. But an excellent concurring opinion. I think, what was that? Yeah, in 2023, about the proper role of the common law judge in our system of government. So I have the pin site, if you'd like. I can share it. But you should go look it up and read it. It actually featured in an amicus brief we did in the Supreme Court recently. So on our featured speaker in this discussion today is Jonathan Skrmetti. Jonathan Skrmetti was sworn in as the Attorney General and Reporter, which I meant to ask what the reporter signified, but I'll ask you after. He was sworn in anyway for the state of Tennessee in that role on September 1st, 2022. He was appointed by the Tennessee Supreme Court to serve an 8-year term. Prior to this role, General Skrmetti served as Chief Counsel to Governor Bill Lee. He also served as Chief Deputy Attorney General to the Tennessee Attorney General. Before he was in the Attorney General's office, he was a partner at Butler Snow in Memphis. And before that, he served as a federal prosecutor for nearly a decade. He has also moonlighted as a cyber law professor at the University of Memphis. He graduated with accolades from the George Washington University, the University of Oxford, and Harvard Law School, after the last of which he clerked for Judge Stephen Colleton on the U.S. Court of Appeals for the 8th Circuit. Of course, despite all of those accolades, many of you might know him better now as the eponym of a pretty significant Supreme Court decision that came down recently, from what I understand. But in any event, with all that said, Justice Campbell, the floor is yours.
Thank you very much, Joel. Thank you, Joel, and thank you to the wonderful team at FedSoc who organized this event. I've sat in on the first two panels, and they were really, really terrific, so I'm looking forward to the last part of the day. I think I can speak for all of us when I say that I'm very relieved there is no fire at this Fireside Chat. It is a delight to have General Skrmetti here with us today. General Skrmetti and I have known each other for a while. We overlapped in the Tennessee Attorney General's office for like 3 or 4 years. So you became Chief Deputy in 2018, and I left in 2022. So we had several years of overlap. And then he was in the governor's office when I was going through the confirmation process for my current position. So he got to accompany me to the various legislative hearings as part of the confirmation process. So Tennessee is really lucky to have General Skrmetti in the state and leading the Attorney General's office. So it's really a privilege to be able to ask you a few questions today and let the audience, to the extent they don't already know you, get to know you today. So I want to start by kind of talking about your time in the Attorney General's office so far. So you have been there almost 3 years. It'll be 3 years in September. You obviously had a big win just recently in the Skrmetti case, and I am curious, do more people know how to pronounce your name correctly now?
Emphatically, yes. It is super weird being it's really weird being the defendant generally. It's really weird when people are railing about Skrmetti does this, who Skrmetti hurts. It's very disconcerting to see those headlines.
Well, tell us about what you view as some of your biggest accomplishments as Attorney General so far, which can include the Skrmetti case, of course.
So there are, the beauty of the state AG offices is you cover everything. I mean, there's opportunities in just about every area of law. And I'm really proud of the work that the team's done pretty much everywhere. I mean, we've been working to continue to elevate the practice on all the bread and butter stuff, utilities oversight, bankruptcy. But the things that I get the most excited about are the regulatory litigation, and we had some phenomenal wins against the Biden administration, where the administration was passing regulations that conflicted with Tennessee state laws. The consumer protection work, where we have been a leader for decades and continue to do really great work with a great team. And then antitrust, which I think is an area of law that is rapidly becoming much more salient. And as you look at the structure of the economy, there's a lot more need for antitrust enforcement. So, that's in the areas that everybody thinks about, like the Google search case where Tennessee was on the trial team. We had lawyers very engaged in that, worked really, really hard, and we're in the remedies phase now in a great bipartisan coalition. But it also extends to the Live Nation case, which happened because Taylor Swift tickets were really hard to get and a bunch of people complained. And it reminded some of us in the office that for 30 years there had been a Ticketmaster monopoly that took advantage of consumers. Antitrust came up in the NCAA litigation, which is my all-time favorite case that I will ever be involved in. The NCAA was looking to enforce a rule that 2 months prior to the head of the NCAA said no longer existed. They were going to have some very draconian enforcement in Tennessee based on name, image, and likeness compensation. And we sued them. And we got the enforcement action enjoined and basically broke the ability of the NCAA to arbitrarily enforce these rules in a way that severely harmed the economic prospects of student athletes. So that's not the case of the century. It's not something that's going to change the world, but it's an important case dealing with some conduct that was deeply entrenched and hurting people. And I feel like antitrust is an area where there's a huge delegation of authority to the AGs, and we need to take that seriously.
I understand that on the day, I guess it was the PI motion was argued, it was in the Greenville courthouse, right, in East Tennessee, small town in East Tennessee, that there was a forklift or something that was parked, a crane that was parked across from the courthouse flying the Power T flag. So UT loyalty runs very deep, especially in East Tennessee. So as you look ahead, you've got an 8-year term as Attorney General. For those of you who don't know, Tennessee is unique in that the Tennessee Supreme Court actually appoints the Attorney General. So I joined the court in February 2022, and we had the Attorney General selection process that fall. So you have an 8-year term, so several years ahead of you. What do you see as the priorities of your office in the next several years?
So there are a few areas that I think are going to continue to grow in importance. Antitrust is one of them. I was just at a meeting over at the Antitrust Division this morning. We've got a great partnership with the federal government. We've got a great partnership across the aisle with states. And given sort of the power differential between some of these companies that are literally the most powerful companies in the history of the world, and it doesn't mean they're inherently bad, it just means there's a lot of opportunity for mischief if there's not concerted oversight. We really need to make sure that we're acting as a check to protect consumers, because absent significant government intervention, there is nobody out there capable of protecting people, and the market's just not dynamic enough at this point to solve its problem in the way one would ordinarily hope a market did. There are structures in place that are inhibiting competition. So that's going to be a continued area of emphasis, I think. Consumer protection generally, as we see more and more technology adopted. I mean, AI is everywhere. It's going to remain everywhere. We'll see what happens with the proposed moratorium, but assuming there's still a state role, and I seriously hope that there is, I expect we'll be very involved in consumer protection, not to stifle innovation, but just to make sure that as this technology is very rapidly adopted, some guardrails are in place. Because as we saw with social media, you can have tremendous harm happen when there's insufficient oversight. And then because of the political valence of the administration and because of where Tennessee is, there's a lot less opportunity to get in and fight federal overreach on the regulatory front. Because I'm not elected, I don't have the mandate to just do whatever I want. And where there's not the conflict between state interests and federal activity that we were seeing more of under the Biden administration, there's just less opportunity. We did sue the federal government recently in a civil rights case involving higher education, and we'll do some of that, but I do hope there's an opportunity to do some more regulatory litigation sometime. I think that's where the states can make the biggest difference, and our constitutional structure has really been out of whack for the last century. I think you see an administration now that's really focused on regulatory reform, but the pressure has to come from multiple directions or it's not going to be a lasting change.
Before, I want to ask follow-ups on several things you just mentioned as we get in a little bit more into substance. But before we move to that, I do want to ask you a little bit about your journey, just your intellectual journey. I saw a Fireside chat you did, I guess, a couple years ago, where you told the story about kind of how you came to your conservative beliefs, or at least a kind of a pivot point. Could you share that with the audience? If I remember correctly, it involves something about sailing.
It does, and because this is an audience full of people who I think are probably relatively nerdy compared to the mean, I feel safe having this conversation, but it's a little embarrassing. So when I was a kid, I lived in Connecticut. My dad enlisted in the Navy, came up, and he bought a dinghy. And then when I was in middle school, he bought a 23-foot sailboat. It was the pride and joy of his life. It was like the highest material aspiration he ever had. And he got really, really, really into sailing it. And as part of that process, and there's a whole, for those who did not grow up on the coast, the scraping barnacles and repainting every year is horrifying. So I did not love the boat. But there were a lot of sailing videos that came along with it. And so Dad would just watch, all these videos of people talking about sailing. And the most interesting and charming of those videos were this like extraordinarily patrician guy with all these like extremely dry comments. And it was William F. Buckley. And I found out he wrote a magazine. So I got a National Review subscription when I was like 14, which is pretty dorky. And started reading that, and I'd always been really interested in American history. I grew up under the Reagan administration, and he was a tremendous communicator about the values that lay under a lot of his decision making. And it all kind of meshed, but it was National Review that really crystallized everything and gave me a lot of the heuristics I still have for understanding what's going on with government.
Let's go back and talk a little bit more about antitrust. So Tennessee has been a leader on that issue and some of the big tech cases. I think early on, especially when states began talking about suing the big tech companies, there was a lot of discussion about whether current antitrust doctrine is kind of sufficiently capacious to allow for effective lawsuits. Can you just share your thoughts on that? And what do you think that antitrust law needs to change in any significant way to be effective going forward as we see different technologies?
So I don't think the core of the law should change. I mean, the law is written. I don't think we need any statutory changes. We got into a situation where there was very little antitrust enforcement because it was excruciatingly mathematical. And you eventually get to a point where you're just flinging economists at each other, and it's expensive and it's slow, and it was made more sophisticated than most governments are able to handle, right? I mean, like when you have these Nobel Prize laureate economists like flinging very dense theory at each other, you know, a kid who took one semester of antitrust in law school is going to have a hard time staying on top of that. But we had antitrust enforcement before it got so mathematical. The statute allows for enforcement in a variety of situations. And we had criminal antitrust enforcement that was happening fairly divorced from all of the complicating factors. And I mean, consumer welfare is not the enemy. You can use consumer welfare as the guidepost for recognizing whether there is a broken market or not sufficient for intervention. But I mean, you can tell a story about how markets don't work, and you don't necessarily need to come at it with 18,000 whiteboards. Sometimes you need to, but there are a lot of cases where the structure of the market obviously compromises the ability of other people to compete. And I don't think the law should be beholden to a sophisticated expert class. I mean, Justice Thomas recently wrote a concurrence about that. You know, the more you engage experts as the arbiters of what the law means, the less accountability you have to the people. And that's a problem. And it's a problem in antitrust just the same as it is in every other part of law.
What role do you think the common law ought to play in antitrust enforcement going forward?
Well, I mean, there's a lot of doctrine that grew up around the Sherman Act. It's a pretty short statute, and there are a lot of cases that have come along. I think the body of antitrust common law pre the mathematicians and economists is also a really useful foundation for going forward, because we did have a lot of antitrust enforcement. Now, part of the problem is there were some fairly motivated people in the old days who were not afraid to make their policy preferences the driving force underlying some of their opinions. And so I think you have to be careful about just picking up all the older common law. The Supreme Court's been working on this, and I think we'll continue to do so. I expect that's an area where we'll see a lot of activity at the federal level, but there's also a lot of opportunity for state common law and antitrust. And I suspect you're going to see substantially more state enforcement going forward, just based on the volume of work that's necessary and the constrained resources of the federal government.
To pivot to a slightly different point, you mentioned the potential AI moratorium a minute ago. As Attorney General, you have been very vocal in your opposition to that. Can you tell us a bit about your concerns and what you see, as a kind of state enforcer, what you see as some of the problems with that proposed moratorium?
So the proposed moratorium is kind of a moving target right now. So the initial version of it was apocalyptically bad. It said no state can enforce essentially any law against anybody who's doing any AI stuff. That's generalizing it a little bit, but that was our takeaway. We could have argued at the margins that we still had Consumer Protection Authority, but there was a lot of language that would have really made our lives difficult. The language seems to be getting better. Senator Blackburn has been working really hard on that issue, recognizing the importance of state enforcement. But AI suffuses basically every industry, often in ways that we don't fully recognize yet. And it is an incredible technology. I mean, you look at how just a few iterations of AI advancement have gone from the Google product that was incapable of creating images of white people to a Google product that can now make movies, like real movies that you have a hard time recognizing as artificially intelligent. Just with the text prompt, and that's over the course of 2 years, and the acceleration's just trending upward. The logistics industry is completely changing because of it. Agriculture will completely change because of it. Medicine will completely change. Education will completely change. There's a lot of hype around technology. There always is, but this truly is the inflection point in human technology history, which is both awesome but terrifying. And there's no federal regime overseeing consumer interests with AI. There are a few federal general statutes, but there's no broad regulatory regime. A few states have different laws. In Tennessee, we have a name, image, and likeness related law to protect, among other things, musicians' voices from being replicated without compensation for them. And we have an Information Privacy Act, Information Protection Act in Tennessee. There's no federal equivalent of that. So if you have 10 years of preemption where no states can act, so there are no laboratories of democracy, the only entity that is capable of regulating AI at that point is the federal government. Well, the federal government is not known for moving with alacrity. If we're relying on Congress to come in after the fact and fill the void, that's terrible for American consumers. And I am not a Luddite. I am so enthusiastic about this. To go back to family anecdotes you don't care about, my dad actually got his doctorate in AI research back in the 90s doing like cognitive neural net simulations on computers. So this is something that I've been geeking out about for a long time, and I am super, super excited. But as we saw with social media, there can be catastrophic, broad population level impacts from technology that goes unchecked. And if you look at the effect on teenagers, the mental health of teenagers in America is not okay. And there is evidence out there, we have it written up in a complaint, that a large portion of that is attributable to the efforts of social media companies to drive engagement among kids. So we have to be really careful that as this technology is adopted very quickly, very broadly, there are some guardrails up and there's somebody holding the companies accountable to make sure that if there are big problems brewing, we do something about it before it's too late.
Well, and you, as you mentioned, you are not a Luddite. As further evidence of that, you taught cybersecurity law for a while as an adjunct. Was that when you were in private practice?
It started when I was in AUSA.
Okay. So, I mean, you will find like no one who likes to nerd out about this stuff more than General Skrmetti, which is fantastic. One of the panels earlier touched on algorithms and how those should be treated for purposes of the First Amendment. As part of that panel discussion, we talked about how our First Amendment doctrine has not really been grounded all that much in originalism over the years. I mean, how do you view those issues? I mean, first of all, just from your own kind of knowledge of technology and your tech expertise, do you have thoughts on how algorithms should be treated? And then to kind of broaden that, what role should originalism play as we kind of think about applying the First Amendment to new technology?
Yeah, so a lot of the number one fact about technology law that you need to know, and this is what I used to emphasize when I taught it, is the law moves slow, technology moves fast. And so, at a time when people were broadly adopting the internet, one of the leading cases was like 15 years old and it said internet in all caps because it was a relic of like an era where that was like this weird novelty. And that was the law that was in place for a long time when the internet was everywhere and people were online all the time. It is really important that we have a First Amendment. It is really important that people are allowed to freely express their opinions and engage with other opinions because it's ultimately a mechanism of accountability. Just like markets, just like democracy, you need the clash of ideas so that people result in better ideas. And we had a much different internet culture 15, 20 years ago. I mean, some of you folks are too young to remember this, but like message boards were a big thing back in the day. And there was a big debate over whether you can have message boards where people can say whatever they want, or if the people who ran the boards were going to be held liable for all the insanely offensive and defamatory things people said. And Section 230 was created as a means of allowing robust conversation on the internet. It was a great law. It did wonderful things in that era. But as we've gotten more algorithmically driven conversations where it's not an organic matter of people finding a virtual place, hanging out there, building community with the people they encounter there, having conversations that are really analogous to, in-person conversations or a letter writing campaign or something, as algorithms drove more and more of the interaction, Section 230 became very different in its application, and it insulated the tech companies from any accountability for putting thumbs on the scale of the net result of conversations. So you had a handful of companies with an incredible concentration of power, right? Most people get their news or information from the internet. Most news agencies are beholden to the internet for a lot of the content that they have. The same companies that were controlling the flow of content were also controlling the advertising dollars and siphoning money out of local and national news agencies to an extent not seen before because there was a duopoly and they could. And so instead of having a robust set of conversations around the country, you had a lot of power concentrated in a few companies who could decide what people were going to talk about. And they were in a position to use algorithms. You know, they would argue it happened organically. We're pretty sure it didn't. To favor certain conversations, disfavor other conversations, favor certain speakers, disfavor other speakers. And there was no principle of neutrality guiding that. So, you know, you end up in a situation where people feel really increasingly alienated from the democratic conversation. That, you know, people used to be able to feel like, I have a voice, I have a vote, I can write an angry letter to the editor. You know, when message boards came along, a lot of people availed themselves of the opportunity to opine frequently. But when people control who hears the message, then you can feel like you're just shouting at a brick wall that's been built in front of you. And that corresponded with the alienation of people from the lawmaking process as we saw more and more regulators get active, legislatures get less and less active, judges take a more active role in policymaking at the expense of democracy. And it was a real problem. So the First Amendment matters, but it matters because people need to be free to have conversations. And if the First Amendment is awkwardly shoehorned into protecting a structure that actually inhibits the ability of people to communicate, it seems like we need to take a look at how the doctrine applies.
You touched on Section 230, and so I want to go back to that for a moment. That was also a topic of discussion earlier today. I mean, as a state enforcer, when you think about the kinds of cases that you'd like to bring, I mean, how much of an obstacle does Section 230 present, and are there specific reforms that you think are needed as we move forward?
I don't want to be pinned down on specific reforms, and I think if 230 is applied as written and as originally understood, it's not a problem. I think the problem is, as technology has evolved, courts that, and this isn't pejorative, I mean, it's hard to keep up with stuff, but courts that have not fully grasped the implications of porting an existing body of law into a new technological context have given 230 a much broader reach than Congress ever understood it to have, in a way that insulates companies from accountability as opposed to incentivizing them to allow for a more robust conversation. So, I mean, the easiest thing to do would be for the United States Supreme Court to read Section 230 and say, this is what it says. But I suspect that there will have to be more action from Congress because the technology is a moving target, and the courts don't want to be making policies, so they probably would prefer the legislature to resolve the issue.
So we've talked a lot about technology, which is fitting for this conference, but you know, I want to step back and I guess ask a bigger picture question. What do you think is the biggest challenge that technology presents for regulation?
I mean, I think the biggest issue, this is going to sound so overwrought, but it's the ability of technology to undermine our mechanisms for self-government. Like, if we can't have robust conversations, if people aren't able to challenge the ideas of other people, we can't have a functioning republic. I mean, it is necessary that we're able to engage. And technology has created, and all of this stuff has physical analogs, but they're not nearly as influential as the technological versions we're seeing. People are getting siloed in echo chambers that are completely impenetrable. You know, different companies are able to advance different agendas, and you've got locked-in user bases, very little real competition, very little opportunity for one ecosystem to check another ecosystem. We have one giant purveyor of content that is literally owned by an adverse country, despite a law and a court decision to the contrary. You know, the ability of technology to draw in our engagement in a way that leaves us incapable of effectively self-governing is a huge problem. And the regulation for that is difficult because it happens in all sorts of subtle ways. I mean, I don't think, for instance, that when Meta was pursuing engagement, they were nefarious. Like Mark Zuckerberg wasn't cackling and drumming his fingers. He was trying to push up engagement metrics. And that's a reasonable position to have in a vacuum. But the downstream effects of that have been really bad for the country. We're extraordinarily polarized. We are not, people aren't dumber, I don't think, but they're just not as learned or learned, depending on the accent mark. Everything is about the immediate context. There's no sense of really history, or you see this like really reactionary grasp for history to try to find something foundational. And you can't really regulate a sense of community. I mean, the government cannot affirmatively come in and tell these companies, you must promote these great American values. But there has to be at least some thought given to how we can check the worst impact of this stuff, whether it's a cultural response, whether it's a legal response, whether it's a policy response. Like it is a time of both great promise and great peril.
I know that you are always very generous with your time when it comes to talking to students and student groups and civic groups, for that matter. Kind of to your point just a moment ago that it might take a cultural change of, just more civic education efforts and kind of a greater community dialogue. Do you have any thoughts on how we can improve on that? What have you seen as being successful in your own career?
So the Baker School at the University of Tennessee is actually awesome. And a bunch of states are doing similar things. I think Tennessee maybe is doing it near or at the front of the pack. But there's a whole school that's been created with an interdisciplinary Institute for American Civics. And the idea is you're going to take a cadre of a couple hundred students a year, educate them in history and economics, political theory, pre-law, just give them the ability to understand our institutions and why they are the way they are, how they function, what the trade-offs are if you change them or remove them, and then send them out into the wild. Most of them hopefully stay in Tennessee. Some of them will be elected officials. Some of them will be attorneys. Some hopefully will be high school teachers, middle school teachers, journalists. And you just ramp up the level of civic engagement via that. They're already reaching out to other schools across the state at the higher education level, reaching out to high schools, and providing the tools to help teachers understand this stuff. Another answer is AI, because if you have a really engaging AI product that teaches kids about civic institutions and American history and helps them understand, okay, what does the world look like if we get rid of judicial review? What does the world look like if we let the president do whatever without congressional oversight? What does the world look like if Congress is meddling with the decisions that the executive branch is making? Understanding how the system checks itself, understanding how that developed historically, that's really hard for an individual teacher to do. But if you can come up with a product that allows kids to engage really at a deep level and ask questions and move at their own pace, we're potentially at the cusp of a huge renaissance in education, or we're going to have, the Clockwork Orange watching short form, like stupid videos 18 hours a day. It really could go either way, which is kind of scary.
So we're going to open it up to questions in just a moment, but one final question for you before we open it up to the audience. I think there are quite a few students in the audience today, some are associates or interns. Tell us about, what advice do you have for them, as they think about their career in the next few years, and what opportunities are there in state attorney general offices?
First of all, we are hiring. I'm in for another 5 years, so if you're in law school now, you can come work for me. And we need good people. It is a weird time in the law. I think, to go back to AI, I think it is a dangerous time to be a young associate. I think a lot of the work that's done by associates is going to be automated. And everybody says, well, we're not there yet. Well, we're not there yet, but look at how fast this stuff is moving. And if you're not in a position to have really solid mentorship in the firm and start building business quickly, I can very easily see someone get left out in the cold. On the other hand, it is a phenomenal time to be a government attorney. And it's not just an advertisement for the office. AI tools will help us do our jobs more efficiently. They'll help us have a bit more of a level playing field, because it's hard going up against giant firms that are able to just leverage 100 attorneys for every one you have. I suspect that because the firms will somewhat constrain their hiring in the future, and we'll see people moving out of firms, that will have really good opportunities to bring great people in. They will have immense, as they already do, immense autonomy, immense responsibility early on, lots of opportunities to learn. So definitely look seriously at government work. Think really hard about, if you're going to a firm, am I going to be one of the special people who gets to stay if the firm lays off 80% of the associates? If you do stay, the future's looking really bright. I think there's a lot of money to be made out there, but it's going to be harder and harder to be one of the people who gets it, unless and all this is predicated on the structure staying the same. Things could change radically, and if you want to be an entrepreneurial legal innovator, it's a great time for that too. The two most important things I can say practically are get a mentor wherever you are. If you're in law school, I was always kind of shy in law school. I didn't want to bother the professors at office hours unless there was a really good reason. I thought it would be annoying for them. They're professors because they like talking to students about the stuff they geek out about. And I really regret not spending more time hanging out with, say, Bill Stuntz or someone who was brilliant and engaged and wanted to talk through these things. So whether you're in school or working, get a mentor, latch on, learn from them, and get into court as much as possible. Because however automated the practice of law gets, we are not going to have the Optimus robots in a courtroom for a long time. So that is an area where if you get good at it, you can guarantee yourself continued employment. Plus, it is by far the most fun thing you can do as a lawyer. I mean, I've gotten to do some really awesome things as Attorney General, and I hope there are more amazing things in the future. I will always think that the highlight of my legal career was making a guy wet his pants in the grand jury. There are things you can do, that's why all the TV shows are about trial law, right? I mean, it's pretty neat. So definitely lean into that if you're able to. Of course, the Constitution will continue to be a contentious topic, and there will be immense litigation opportunity there. And then the one other thing is antitrust does seem to be gaining momentum. So if you're trying to figure out an area to try to specialize in, I think you'd be steering yourself in a good direction if you did that.
All right, with that, we will open it up to questions. And I think someone has a microphone, so if you'll raise your hand, the microphone will come to you.
Is this on? Okay. Thank you very much, General Skrmetti, and congrats again on your recent win at the Supreme Court. Maybe I'll ask you a question at first about that one, and I'd like to talk to you about AI real quickly. By the way, Caitlin Diaz, the Washington Examiner. So on your latest victory at the Supreme Court, I'm curious what your thoughts are on the next stages. As we just saw in the orders list today, we saw a multitude of states having these appeals court decisions sort of sent back for further consideration. A couple of the things that we still don't really know a whole lot about is, how is this going to apply to birth certificate cases, and how is it going to apply to gender sports cases? We have another orders day on Thursday. Do you think that there's going to be any sort of movement on, where the next steps are going to be at the Supreme Court next term? Or do you think we still have some more developments to go through in lower courts?
So my suspicion is the court is trying to avoid doing too many of these cases. It's such a contentious issue. They want to give the lower courts the opportunity to address all of these questions. The opinion in my case is relatively narrow, and I think there's a lot of opportunity for lower courts to engage in some tea leaf reading about where the court wants to go, but also to get some more granularity there. So my guess is there will be one or two more cases, maybe next term, maybe it'll be a little longer. I don't know. I'm not a very good court prognosticator. I'm still surprised there was an effort to seek cert in this case. So, and I was pretty surprised it was granted too. So we'll see. I mean, this is guidance on a constitutional issue, and we hadn't had that from the Supreme Court before. I don't think anybody's in a rush to start laying down doctrine. My guess is the court wants to give the courts of appeals some opportunities first.
Brief AI question. On the way that courts are handling lawyers using AI in the courtrooms, it seems like there's a lack of consistency happening there. Do you think that there needs to be more of a standard approach, like on the federal level, to the way if a lawyer is caught using AI, is there something that needs to happen, like like a uniform, or should it be a situation where judges handle it case by case?
I know some judges, including Judge Starr, have laid down orders about this. From my perspective, the biggest issue with using AI as a lawyer is legal ethics. You need to make sure your clients know if you use it. You need to make sure that you're not making any misrepresentations based on the computer being stupid. Done right, it should be seamless. I mean, it should be like having a really high energy, if somewhat naive associate doing a lot of work for you. And so in the long run, I think there probably won't be that much court regulation of AI as long as it's not showing up in the briefing. The products are getting better, they're getting better faster, and as they get better and more reliable, and there are more mechanisms built in both at the attorney level and at the technology level to avoid the hallucinated cases, I think courts will probably say, however you produce this brief is fine as long as you're being transparent about it, as long as there's human oversight by somebody who's passed the bar and is subject to bar discipline. I don't want to put words in the judge's mouth, though, so that's just a guess.
I just wanted to ask about antitrust in particular. I don't think it's a secret to anyone right now that there's immense tension within the conservative movement between maybe the old guard consumer welfare standard folks on this issue and maybe the new right on the other hand. And so I'm just curious where you see things going and where you'd like to see things go with respect to antitrust.
So I think it's really the old guard is the old guard for a reason. Judge Bork was a towering genius and incredibly important for American jurisprudence, not just in antitrust, but in everything. And we should not lightly cast off things that he spent years thinking really hard about. That said, the new right is all about accountability to the people and skepticism of experts. And antitrust is no different. And to the extent that antitrust went off in a very expert-driven direction, that's a problem. I think consumer welfare as the guidepost makes sense. You don't want an unmoored antitrust doctrine that's just, you're a big company, I don't like you, therefore you must be violating the antitrust laws. I mean, there's got to be something anchoring such that people can know in advance whether they're violating the law or not. There is a tension there. There's an academic tension. There are certainly NGOs that are really engaged on one side or another. I thought Makin Del Rahim did a really good job of bridging that gap. I think as the conservative approach to antitrust continues to evolve, you're not going to see a radical break with the past. I think you're going to see refinement of the techniques used and of the willingness to use antitrust enforcement. But a lot of that's structural. As more C-suites have gotten more engaged in politics on the other side, as industries have consolidated more and more, the world of the old guard, where there was generally a lot of competition and where companies were generally focused on making money and not on advancing an agenda, isn't necessarily always the case. And so from a practical perspective, I think there's a lot of incentive for the right to coalesce around some new realities in antitrust.
So on something completely different, but still pertinent to what you said, in light of what AI can already do and what we can all imagine that it will be able to do in 5 years, let's say, if someone, as far as you understand the state of the law nationwide on this, if someone were to use AI to produce a film that included both voice and images of movie stars that are long dead, like Marilyn Monroe, would this violate any known laws?
I'm going to punt on that. I think it's a super interesting question. We have a statute in Tennessee that has not been tested yet and that I am not fully up to speed on, so I don't want to make any loose comments that would inadvertently prejudice my clients. But it's a super interesting question.
General Skrmetti, good afternoon. I think most of the people in this room join in congratulating you in your recent victory in the Supreme Court. And a few days after that case was decided, there was an article published by Professor Hadley Arks arguing that the court's approach in the case was basically misguided. All this discussion about equal protection and line drawing is really just missing the fundamental point, which is that men and women have a nature, they're intrinsically different, and you can't switch from one to the other. And it's that natural law truth that really ought to have governed the decision of the case and cases like it. And so I'm curious to ask you, to what extent do you think that natural truths, natural law, should play a role in the decision of cases like this? And how do you predict that natural law may play a role in the decision of future cases?
So, my worry about natural law is always giving the power to judges to make big sweeping policy decisions on the basis of their interpretation of natural law. I mean, I think there is a natural law. I think it's inscribed on the human heart, and I think it's expressed generally through our democratic institutions. But I'm really leery, and I think, courts have a role. Courts have a very important role. They shouldn't be shrinking violets. But at the same time, the more the courts explicitly lean on natural law, the more you're going to see courts 30 years from now come in and say, actually, natural law means this, and then we'll be back at the Warren Court, and we'll have to go through the whole cycle of, 3 generations of trying to fix things again at the expense of American democracy. So I very much enjoyed reading that piece. I completely understand the concerns. But on the flip side, we need to look ahead strategically and not just live in the moment altogether. This court had any number of different options for going further with the decision than it did. It was, I think, a very deliberately measured and narrow decision. But if the court starts saying, well, this is just how it is, and the legal outcomes flow from our understanding of human nature, then, we're really poised. I mean, it's, the analogy that gets abused to death, but it's so true, is Boromir and the One Ring, right? Like, hey, we've got this great ring, let's use it to do good things. But it's concentration of power that's the ultimate problem in American constitutionalism. The whole system is built to avoid concentrating too much power anywhere. And when you give the courts the authority to say, well, this is just how things are, and therefore all of these ramifications flow from that, I mean, we can agree wholeheartedly with where the court's coming out on some of these cases, but that doesn't necessarily mean that it's a good idea to make the court the arbiter of human nature and not just the arbiter of the constitutional text. So I recognize there's a lot of younger folks in the room. You probably... I know things are changing. You probably have super sophisticated arguments about why that's wrong that I have not encountered that much. But I'm like, if you're really young, you also don't remember the bad old days that well. And whatever we do now is going to have ramifications. And if we're going to be a country that's worried not just about winning in the moment, but about securing the blessings of liberty for ourselves and our posterity and building a structure that will remain for centuries and for generations to make our kids and our grandkids and our great-grandkids free and prosperous, I mean, I think you have to be really, really careful about giving a thumbs up to any concentration of power that could potentially distort the system in the wrong hands.
I'd like to ask a question about Section 230. You said that Congress may have to step in with that legislation because it's not being applied as it was originally intended. Do you think that could happen organically with the advance of technology, or do you think more things need to happen to accelerate that?
I mean, I think it really depends on how much the courts continue to apply and, in my view, misconstrue Section 230. If there are a number of significant bad decisions below that keep the pressure on the Supreme Court, you could see the Supreme Court acting. You could see Congress stepping in to act. It's one of the rare areas where there does seem to be at least the germ of a bipartisan consensus with potential supermajority opportunity. People are really worried about technology. People on both sides of a very polarized political spectrum are worried about technology. So, I think it'll be driven by events. I think either there will be a really significant harm or a really bad case, or something will raise the salience of the issue, and then maybe Congress acts and produces something great, or maybe the courts step in and narrow 230, and Congress considers whether something additional is necessary to deal with the more algorithmic-driven stuff.
General Skrmetti, I have a question about what you think about Justice Barrett's opinion in the universal injunction case, and maybe you could speak to, people who love it or hate it if Biden is president, and love it or hate it if Trump is president.
Yeah. So first of all, we should not have district courts that are invalidating the exercise of core executive authority in ways that make it difficult for the president to be the president. If things had continued the way they were continuing this administration, I guarantee you that the next time a Democratic president was elected, they would not be able to unlock the front doors of the White House because there would be like a slew of injunctions. That's no way to run a country. It's terrible. Like, whether you agree with the president or not, they need to be able to be the president. So we filed an amicus brief in support of the president's position with respect to scope of relief, as well as with respect to the 14th Amendment interpretation. I think this is really good guidance from the court. The big question is what happens when you're not talking about core executive authority? What happens when you're talking about regulatory authority, which is already something of an imposition on the legislative branch, and where you have the APA that I think offers vacatur as an option? That is my biggest concern, because we were merrily suing the Biden administration and enjoining all sorts of rules, and I don't feel the least bit bad about that. But enjoining a rule is different than telling the president you're not allowed to instruct your people to do X, right? One of them is an imposition on third parties. One of them is just the president managing the executive branch. With the military, the president is the commander-in-chief. The court should be extraordinarily leery of stepping into military situations. With foreign affairs, the president needs the latitude to conduct our foreign affairs. Our structure was built that way. The court should not engage with that. So in my view, there is room for the courts to check executive authority, even at the preliminary injunction stage, but it's been overused. And outside of the regulatory context, I think it is very dangerous. So I thought it was a great opinion. I'm excited to see the ramifications. There's a lot left to do in terms of litigating the contours of it. And I think in the regulatory realm, where you have administrations essentially writing complicated bodies of law, you're in a much different footing, and I hope that this decision isn't read as blocking courts from stepping in when there are bad rules that are about to go into effect.
Probably have time for one more question, if anyone has one.
Hi, I'm sorry, I'm very nervous to speak because I'm not a lawyer and I know very little about the law. But can you sort of talk about what the impact of your victory at the Supreme Court will be on the other transgender-related cases, like Trump versus Orr with the transgender passports, and the case involving the military? So
there are different ways to read the decision, some broader, some narrower. I suspect it has portents for the military decision where, you're talking about medical conditions and the government's ability to treat medical conditions differently. That seems pretty analogous. It may or may not be analogized to the passport and driver's license issues. There are some theories I've read that are pretty persuasive that it could be used to resolve virtually all of the litigation out there about everything from Title IX to the military case. I don't know that courts are going to read it that way. You know, the weird thing about it, from my perspective, is it's a relatively narrow ruling. It could go either way legally, but and again, like, it is so awkward to talk about a Supreme Court case when your name is on it, because it just feels like narcissistic. But like the cultural impact, like, there was a phenomenal article in The Atlantic yesterday by Helen Lewis about how this is kind of an inflection point where people are realizing that they were in a misinformation bubble on the left, and people are reevaluating the evidence. And, you know, a lot of people on the political left did come out against it, but a lot also either stayed quiet or had very modest criticism. And that could be an indication that the polarization is thawing a little bit in the face of evidence, as it should. I mean, if you look at what Western Europe's doing, Western Europe is not a Republican Southern Baptist polity, right? Like, their politics are totally different than ours. They're reaching the same conclusions as Tennessee, not because of any animus they have, but because they're looking at the evidence, which is what people ought to do. So, you know, I think in other legal contexts, it remains to be seen, but it certainly has spurred a lot of conversation and caused people to stop and think about what was really an unchecked cultural juggernaut for a while, where there was a lot of elite authority being used to push a very, very broad agenda. You know, and by the way, I make sure to say this in every audience, like, the kids that are dealing with gender identity issues are having a really hard time. Their parents are having a really hard time. The goal is not to crush them. The goal is not to exterminate them. The goal is to make sure that we have evidence-based medicine that is leaving children in the best possible situation as they deal with really difficult situations. So, I think going back to the First Amendment point, more conversation is always good. Putting people in a position where they have to be accountable for their ideas and where they're exposed to challenging ideas, challenging evidence, creates better results. And so in that respect, this is a radically pro-popular sovereignty decision, and I was super glad to have my name associated with that.
Okay. Please join me in thanking General Skrmetti.
Thank you, Justice Campbell. Thank you, everybody.
Thank you very much, General Skrmetti and Justice Campbell. I appreciated the reference to William F. Buckley and sailing. It is very hot in this room, and like sailors, I think we've all been praying for a breeze as we've been listening to you. But you all are in part to blame, of course, because were you not both such great draws, the room wouldn't be filled and the air conditioning would be keeping up. So I do apologize to everyone for the heat, but I don't apologize for this wonderful conversation. We look forward to having you back. You're so generous with your time, so kind to the society. We're truly grateful. We look forward to having you back again soon. So thank you very much. One last logistical thing. Our next panel will start at 2 o'clock in the other room.